right, Judge, I believe you are good to go.
All right, good afternoon. The chair will call this third subcommittee meeting, inquiry of staff, real estate client referral to law partners business, to order. I'll begin by reading the conflict statement. Members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or the appearance thereof. All right, hearing none, I welcome members of the subcommittee. I greet those who are observing this meeting by live stream. The subcommittee is going to, I'm going to turn it over first to Mr. Oaten, and then I'll try to steer the discussion. Mr. Oaten, do you have a report?
Sure. So, as you all remember, we've spent the past couple of subcommittee meetings with a number of folks participating in our meetings to better educate the subcommittee members on the issue at hand. Of course, the issue that I won't spend a lot of time recapping because I think we're all on the same page, but this question of a lawyer who is serving as a closing attorney, acting both as closing attorney and potentially title insurance agent, which the Ethics Committee and State Bar Council has answered previously. And I think, and they previously answered that a lawyer cannot wear both hats at the same time. But then kind of a related question that has not been answered by the Ethics Committee or thereby the State Bar Council is whether or not a lawyer's partner or somebody else in the law firm, basically their ownership of a title insurance agency, imputes, or if that conflict imputes to somebody who's doing a closing transaction for that particular lawyer. So we need to discuss all these things. There is no draft opinion on this yet. And that is primarily because I was looking for this meeting to inform the direction of that opinion. The subcommittee has heard from members of the real estate bar who have a variety of opinions. I think there's really kind of two camps. Either some want to see the ethics rules in North Carolina change to allow a lawyer to serve as both closing attorney and title insurance agent, provided there's appropriate disclosures to the client, and others want to maintain the kind of the separation between those two roles. So we have heard from members of the real estate bar, particularly leadership in the North Carolina Bar Association Real Property Section, RELANC, as well as members from the title insurance industry, particularly Mr. Jeff Benson with Investors Title. And we have received a number of comments that have all been provided to you for your consideration that really represent all different sides here. So what I was hoping for today in looking at drafting a potential opinion is a conversation with the subcommittee that answers those questions. And those questions being the three questions that were posed in that introductory memo that was provided to the full ethics committee when this matter was introduced. And so I'm assuming, because of the the experience that we all have on this subcommittee, that those I don't need to give any more detail. I think we're all familiar with the inquiry. So I think maybe the best place to start, Judge, would be to see if there's a consensus on the subcommittee on that very first question that was posed to the or through that introductory memo, which was, is there any reason to change North Carolina's historic stance that a lawyer cannot wear both hats? They cannot serve as both closing attorney and as the title insurance agent in a particular closing transaction. And I think from there we can move on to the subsequent questions.
I think that's a good place to start. I'd like to get an idea where we didn't hear from many subcommittee members during the last two meetings. We heard mainly from practitioners in the title insurance game and the real estate area of practice. So I wanted to hear from some of the subcommittee members, regardless of what area they practice in, and see if there is some consensus on one, two, or all three of these questions. Who wants to lead it off?
Tom, I'll go first if you'd like.
Thank you, Mr. Lynch.
I've kind of been deferential to my fellow committee members because this is my world and welcome to it, I guess. But I like the way that North Carolina has separated the roles of folks that are part of the real estate process. I think it's inured to the public's benefit. In my opinion, there's no problem with having a high bar. I think we ought to have high standards in North Carolina. I think we do in many respects in the ethics world, and I think this is a great example of it. I think we have relatively low premiums, and I think we are very protective of the public, which is really the pole star that we all guide by when we're dealing with issues on the ethics front. I think it is difficult for somebody to wear the two hats that we're talking about in connection with our deliberations. And quite frankly, I think the statutes that Brian and Britt provided us that are part of the materials in connection with today's meeting kind of demonstrate that there's a legislative effort to kind of separate those roles. What we may be talking about here may not fit right in the letter of the law in those two statutes, but clearly what we have done for 50 years in North Carolina is consistent with the spirit of those two statutes. So I would say no to number one, if that's kind of the focus of this part of our meeting. I don't think we need to change what we have done. I think we should be proud of what it's done for the public. And I think that there can be problems big problems if we decide to change course.
Okay. Brian, would you mind if I asked Mr. Lynch to weigh in on question 2 and then ultimately the referral to a law partner's business and the imputed conflict?
Yeah, and I guess I'm absolutely fine with whatever direction you want to take. I am curious, since that inquiry number 2 starts to go into the imputed stuff. I'm curious to see if everyone on the subcommittee agrees with Mr. Lynch or anybody has a different opinion as to question number 1, because that might just be, I guess that once we get to 2, we start going in a different direction.
Right.
I agree with Craig on 1. Absolutely. I see it every day when I do loan closings.
Brian, I don't have a practice since I'm a public person on the council, but I would support Craig's, and I think it was Martin just spoke up. I would support them, and that the answer would be no to change.
And to be clear, Patty, I appreciate you weighing in and being a part of this because we need the public perspective. We have practitioner perspective, but I really do appreciate you being involved in this and offering that perspective on behalf of the public, which we serve.
Well, you're very kind. Thank you for saying that. I can go on and describe to you that I do think that it's in the public's best interest for there being 2 separate entities in both of the separation between the real estate and then the title insurance and wearing it. And so I think it's in the public's best interest. And I'm proud of how things have gone for the last, I didn't realize it's 50 years, Craig, but for whatever number of years it's been, I think it's worked well, and I think we serve the public in doing that.
Thank you, Patty.
I agree with the others who've spoken. I've put some thought into the arguments advanced by the people in favor of a modification, and I don't find them to be compelling. I can say more about why if it's helpful, but I don't have any disagreement with those who've spoken so far.
Does anyone have a differing opinion? And No? Does anybody have a differing opinion but doesn't want to speak, but just wants to maybe think about it, weigh in at some other time? I just want to take the temperature of the room.
I don't disagree with anything that's been said so far, and my perspective is truly not far removed from Patty's because I am in a practice far removed from real estate, and my only real experience with this issue has been as a purchaser of real estate and not as a practitioner. But I agree, this has been a
Brian, do you have any questions about rationales or anything that you want,
No,
how you want to
I
approach a draft with? What kind of language or?
I do not. I mean, I would envision, given I guess, the consensus expressed by the subcommittee, that inquiry number one, the answer would be no, and that it would be no, and really kind of reiterating North Carolina's long time position with reference to the statutory framework that we've discussed, that the different participants have discussed, and the subcommittee has reviewed from the outset of this inquiry. So I feel that one is pretty straightforward to draft. I don't think it requires any sort of new analysis because that analysis really is has previously been set out as to creating the conflict of interest under 1.7. And I know that there was some argument advanced by a variety of participants about whether Rule 1.8A and kind of the rule that permits a lawyer to engage in a business transaction with a client, whether that I guess provides a pathway, if not really overrules any sort of conflict, a personal interest conflict that is viewed under Rule 1.7. And I think that's kind of the thing. 1.7 is that current conflict of interest, a personal interest that the lawyer has, saying that, and that's the historic stance, that a lawyer's ability to serve to wear both of these hats creates that personal interest conflict where a lawyer cannot, even with a waiver, serve in both capacities because of the significance of that conflict in their duties and carrying out the transaction and so forth. I have personally seen the subcommittee. I feel like the subcommittee has been looking at this as, even though there exists now in Rule 1.8A the ability for lawyers to engage in business transactions with their clients, that the principles and the prohibition that we see in 1.7 still applies, and that the fact that the rules permit a business transaction with the client does not somehow overrule the considerations that are really kind of fundamental to practice in Rule 1.7. So I say that just because I know there has been discussion about incorporating Rule 1.8A into the analysis, or at least acknowledging that it exists, because a lot of the historical ethics opinions that have dealt with this were drafted before 1.8A. And unless there's any sort of objection, I think I would probably have a sentence that recognizes, despite the rules permitting a lawyer to engage in a business transaction, the principles, the personal interest, or the nature of this particular conflict is not something that can be waived. It is too significant to simply do away with, or through disclosures. So this is where we start getting into the weeds on conflicts. And so I don't want to get too far into the weeds, but I just want to recognize I've heard that from some of the folks that have offered their opinion. But I am taking from the subcommittee's expressed opinions here that Rule 1.7 prohibits this. This is a current conflict of interest that cannot be waived for a lawyer to serve in both hats.
And it would also require some kind of legislative change, wouldn't it?
On top of that, yes.
Is that cited in the bar's prior opinions? 'Cause
Yeah,
that happens-
there's some reference to the statutes and in some of the older opinions. So I think
I didn't know if the statutes came later or, all right.
no, the statutes have been in existence for a while and have been referenced in some of those opinions. So I feel like I have enough direction, unless there's anything else anybody else wants to put out there. But I feel like I have enough of an idea of where the committee wants to go, the subcommittee wants to go on that particular question, reiterating that it's a conflict of interest that cannot be waived, and it just really kind of hearkening back to the historical stance that the state bar has taken, especially in light of the statutory framework that's offered out there.
All right. Well, that takes us to question 2. And this is where we begin the imputation of conflict.
Yeah, so this one, just so I just want to be all on the same page, not just for the subcommittee, but for anybody else who's watching on the YouTube feed right now, which I recognize there's 61 people watching right now. I'm telling you, this is the inquiry that sends the state bar into the stratosphere of social media popularity. The inquiry number 2 deals with the situation where we have attorney A who's serving as a closing lawyer for a closing transaction or a real property transaction, and lawyer A or attorney A works at a law firm where attorney B is a partner, and attorney B owns a financial interest in title insurance company. So the question is basically, can attorney A, in serving as closing attorney, send their client to attorney B or attorney B's title insurance company? Understanding, of course, that we just answered that a single attorney cannot wear both hats. Now we don't have the single attorney wearing both hats. We've got attorney who's serving as closing attorney being separate from the other person, the partner in the firm that owns the title insurance agency. And so the question being, can attorney A refer the client, the closing client, to their partner's title insurance agency? Or, because of course the attorney, the partner who owns the title insurance agency could not serve as closing attorney, and that would be that partner's conflict. Is that conflict actually imputed to attorney A such that attorney A could not refer their closing client to the partner's title insurance agency?
All right. Law partners. How do you feel about that, Craig?
I'm going to use a scientific term here. Makes me feel very icky for that to be permitted. I think in terms of NC Gen Stat, let's see if I get the number right here, 58-26-1, it talks about people who could be employees or agents of the title company and how they're excluded. And to me, again, it's perhaps not in the letter of the statute, but certainly in the spirit of it, because the interests of A and B are very different. Somebody who's got a proprietary interest in a title company or ownership interest, they'd like to basically eliminate risk. And attorney A, as the person who's going to do the real estate work, wants to make sure that his or her client is fully aware of all the issues relating to title and would love to really have a very, very specific list of title exceptions. Whereas attorney B, wearing the title insurance company hat, would have an interest in a very minimal number of exceptions, if any, listed. I know we've kind of had some discussions about whether a title policy and or a deed that just says basically that title is subject to all matters of record and to all matters that would be shown on a complete and accurate survey. That's very generic, doesn't really identify any issues. And I think if I were representing the purchaser of the property, as Attorney A, I would prefer that the title policy as well as the deed have a laundry list of specific exceptions. So I guess I would answer that one no as well. I would not want to see a change there. I think it's a clever workaround, quite frankly, if you allow it to happen, and not one that I would be very pleased about.
Right. Anyone else believe it's different if it's a law partner? Everybody agrees with Craig.
I keep coming back to the opinion that we have to give us a little guidance on the spousal interest. And while I know they're not spouses, that is the closest analogy I can draw. So even whether it be substantial or insubstantial, it's still out there. And I agree with Craig's very, very scientific term of ick.
Well, one profits if the other profits, one
It
doesn't.
doesn't. There's no way to separate that out because of the fact they're in that relationship. If you're a separate title company, not practicing law, and I appreciate Britt and I presume Brian for putting together all the information they sent out for us to review. It was very neat to be able to see it in one place and go through all of it at one time and see kind of the evolution of how things, and then also the not evolution, because these things keep turning up. And even though we're saying you can do these situations where they're law-related services, they're not law. This is law. So whether it's a title opinion or the title company, this is not like advising a client on what they should invest their money in. It's not an accountant who's providing accounting services. This is straight up law they're making a determination of, and they're doing a legal analysis. And so I don't see where you can separate those two apart and create a law-related exception, because we're just doing title insurance instead. It's not really law-related. Well, it is law-related, but it's even more so. It's the law. It's what we're in. I think, Craig, you're right. It's this counterbalance between, I want to get it closed. Title insurance company says, well, you can get it closed, but I really don't want to be on the hook for anything. And so that's a hard thing to balance.
Well, it's also central and essential to the transaction.
It absolutely is. You don't.
The legal
I mean,
service.
I can do estate planning for you and then say, well, I also got a financial arm, but those two aren't necessarily the same.
Right.
I mean, it's all related, but it's not the same. When you do this title work and you get this opinion, I mean, the lender's not going to let you close unless you've got that opinion. You got to have the title insurance.
Right.
Brian, once again, as a public part of the council, I again feel like this is, to say no is in the best interests of the public. And having them have two separate entities be a part of this real estate issue, I think is important.
Well, thank you, Martin, Patty, and Craig. I want to ask the subcommittee, this is where I'm going to preface this. We're going to get into the weeds of conflicts, okay? But this being a question about the imputation of conflict, we have recognized that the lawyer who is conflicted out because they are serving as closing attorney and they own the title insurance agency, or they have an ownership interest, some sort of financial interest, that is a personal interest conflict. Personal interest conflicts generally are not imputed to other members of the firm. Rule 110 does say that basically, that's Rule 110A is the I guess that's the primary part of the rule, where it's saying, basically lawyers that are associated in a firm have to share the conflicts. If one person at a firm can't do something because there's a conflict, it's not like you can just send it to the person next door. There's an imputed conflict. And Rule 110A at the very end, or I guess as it's talking about, these conflicts are imputed. Current conflicts, former client interests, or former client conflicts are imputed to the other members of the firm. That a prohibition based on a personal interest is generally not imputed to the other members of the firm. unless the that personal interest conflict presents a significant risk of materially limiting the representation of the client by the remaining lawyers in the firm. And so I want to be very thoughtful in addressing this issue that, generally speaking, personal interests are not imputed to other members of the firm. Is this a scenario, however, where the personal interest conflict experienced by lawyer B, who has that financial interest, the ownership interest in the title agency, is this scenario one that actually does present a significant risk of materially limiting the representation of the client by attorney A, who's serving as the closing attorney?
Well, I mean, Brian, the whole time, the attorney A has got in his mind, I'm needing to potentially, even though it may not be overt, it may still, and it's out there, is if B is not making money, do I still have a job? And I've got to make these referrals potentially there, or I will not, or will I vigorously act on behalf, very similar to the spousal, will I vigorously act on behalf of my client when the title company really would vigorously like not insure as much as they possibly could? Would this then affect me in being able to give as good of a representation to my client as I would if it were not an issue at all? And I just, I relate it so closely to the spousal opinion that it's hard to divorce that from it and say, well, no, it'd be fine, no problem whatsoever. I think they can get by with it. We could do it with something else, a waiver or something on informed consent. But no, I think even that situation, because that financial interest, and even when you look at 58A, that speaks to it as well, and saying there cannot be anything that comes back. I mean, granted, it may be a separately owned, but it's part of the conflict in that you have it. It is separately owned by the spouse. Same thing. It's still out there.
And so, talking about the spousal interest, I agree, Martin. That one, it feels much closer to attorney A when it's the spouse, because that owns the title agency or has an ownership interest, because, presumably there's some sort of shared finances. There's some sort of potential reasonable financial benefit that the attorney still experiences when the spousal interest is met. Or I guess when the spouse gets the benefit of the business. Having a separate person, I guess it's your partner. It's not you, it's your partner. Do you still see there being a potential material limitation for attorney A in saying, I guess what I heard you say, and please correct me if I'm wrong, that essentially attorney A is looking at partners, title agency, and saying, well, even if it's not a question of whether I'm going to maintain a job, it's just that I have this relationship with my partner, and it's, maybe it's short-term, long-term, but that person's financial success, even if it doesn't directly benefit the firm, is something that essentially is interfering or has the significant potential to interfere with my judgment, my independent professional judgment for my client.
I think that's exactly right, because that's where it comes in. You can't just remove it. It's there as long as there is that connection fiscally there, which it is. You're in partnership together. It's going to be how well one does, how well the other does. It's all like in that one relationship, even though it's a separate company.
Well, Brian, as you said that the conflicts are not generally imputed to members of the other members of the firm. Personal conflicts are not generally imputed. That's generally. Are there examples where it is that are akin to this situation?
Off the top of my head, no. I'm sure there are. I think the thing that, whenever I teach conflicts in law school, and I recognize that generally, the imputation of conflicts and personal interests are not imputed to other members of the firm, including something like I don't know, if the opposing party is represented by your partner's spouse. That's a personal interest conflict that would prevent husband and wife from being adversarial to each other. But it's not necessarily imputed to the other firm members, but it really is kind of it depends. And I'm wondering if the same analysis kind of applies here, because it depends, meaning that the personal interest is not imputed, personal interest conflict is not imputed unless that personal interest conflict that the firm is dealing with presents that significant risk of materially limiting the representation of the client by the other members of the firm. I see that as, let's say, if you are you're a lawyer at a 200-member law firm, and there's someone whose spouse is representing the opposing party, and you've never interacted with that person. You're not in the same division or anything like that. You're not in the same practice area. You maybe saw them at a holiday party. But really there's no limitation, versus you are in a 2-person firm and you know that partner's spouse, and maybe that person's spouse is, has I guess gone to not just holiday parties, but been to your house to celebrate the holidays, because you are a close-knit firm. There's 2 people in the firm. You all have practiced together for the past 30 years. Your families have interacted for the past 30 years. Those circumstances, I think, contribute to the potential for a material limitation on that lawyer's part, even though it's not their spouse that's representing the other side. They recognize that there's maybe it's the relationship they have with the opposing party's counsel, your partner's spouse. Maybe it's something that you have such a connection to your partner that you could potentially, I guess for lack of better terms, pull your punches when you are representing somebody against your very good friend partner's spouse. So it depends on a variety of circumstances there. This situation, I guess that's where, this is kind of a segue to the New York opinion that I sent out to you all. New York issued an opinion on this issue just last month. It was about 5 days before our last subcommittee meeting, and I did not become aware of it in time to send it out to you then. But I sent it out to you all in anticipation of this meeting, and the New York opinion, granted, New York has some slightly different language in their imputation rule, but they basically came out when they were analyzing this same scenario. First, can a lawyer wear both hats? They answered no, that it's a conflict. And second, in this question about the imputation, New York answered the question that essentially it was kind of an it depends. They were saying that it's not just an absolute no, that basically says that in this question of imputation, it's a no if the I guess the relationship, the referral of your closing transaction to your partner's title insurance agency presents a significant risk that the representation will be materially limited, or that independent professional judgment of the participating lawyers will be adversely affected. So it's they didn't answer it cleanly, yes or no. They just said no if that referral is going to be materially limiting. It's one of those answers that I understand the answer, but yet it doesn't answer it clearly. It's going to result in, say, for grievance purposes, if somebody files a grievance against an attorney, the grievance committee, the disciplinary hearing commission in particular, they would have to sort through the arguments of the parties and the facts that are presented to demonstrate whether or not that referral did create a significant risk of material limitation of the representation. So I don't know. I guess that's all to say that the New York opinion, while I understand it, I don't know that it's very helpful to practitioners, because it doesn't really answer the question. It just kind of gives them a thought of, well, you need to consider this, but what factors contribute to something being materially limiting on a representation or adversely affecting the independent professional judgment of an attorney? that's something that I think is left to interpretation. And I don't know that it would really clearly guide the profession here. So, but nevertheless, the New York opinion, I think, is it's there. Like I said, wanted to provide it to you all for your consideration and review. And it does present an option to answer this that I think is accurate, if not really helpful.
Does anyone want to comment on that or on the New York opinion?
I will say that I believe that it does create a risk that there could be a material limitation on what attorney A could do for his or her client. And if that's really the touchstone, then I think Martin's analysis is spot on.
And that's exactly what the New York opinion says, isn't it? Significant risk, material limitation on independent professional judgment.
I think what Brian's concerned about is, of course, the wonderful little words in there, a reasonable lawyer. And of course, having the grievance committee be able to figure out what a reasonable lawyer would or would not do would involve the considerable discussion and determination in making that call, whether it would be reasonable or not. Which of course appears based upon, if you go up above in that opinion, this would be a non-consentable conflict of interest as far as before you get the imputation.
So I guess maybe that's the thing, the direction that I would look for from the subcommittee. I'm hearing the answer to number 2, that the subcommittee feels the answer is no, that a lawyer cannot refer their client to their partner's title agency, because though it is a personal interest conflict for the partner to serve in that closing capacity, that conflict that the partner has created through their ownership of the title agency is imputed to attorney A, and that it's imputed in the sense that the very nature of title work and the necessity for the kind of, I think you, Judge, you had said the really the centrality of the title opinion to the transaction, to the legal service that's provided, is such that this referral does present a significant risk of materially limiting the representation of attorney A. And that creates the imputation of this personal interest conflict to the other members of the firm. And therefore that's what justifies the answer of no. So am I understanding the subcommittee's thought there?
I think you have, Brian. I think that succinctly puts it from my
Okay.
perspective.
I think that does sum it up. And Brian, it's going to be your challenge to explain how this is different. I mean, this is an exception from the general non-imputation.
Right.
We can't have one. We're going to have to distinguish that.
Well, and I guess I'm also hearing the subcommittee maybe want to take a slightly different approach from the New York opinion, in the sense that the New York opinion says, well, no, you can't make that referral if there's a material representation. I'm hearing the subcommittee want to say, no, you can't make that referral because this referral is just by its nature kind of inherent material limitation. So I will I'll take that into consideration and try to draft something. I very much imagine we will get some comments on that. I would encourage anybody who is listening right now to wait to see the opinion first, just for whatever it's worth. If you're watching this on live stream, or if you are watching this at a later point and you want to comment, I would really encourage you to hold off on your comments until you see the actual language of the opinion that the subcommittee has agreed upon, and then the ethics committee has agreed to publish if we get to that point. And that's something there's going to be a new, just again, this is purely informational for everybody. We do have a new email address that people can send comments to, just straight up comments@ncbar.gov. That's something that's a central location for everybody to submit a comment, whether it's a rule amendment or an ethics opinion. But again, I want to emphasize it may be completely irrelevant and a waste of time to comment on ideas that are being discussed right now. Wait for the language of the opinion, because it will still go through a couple of different iterations potentially before the committee actually gets to the spot where they can publish it. So for whatever that's worth, just want to make sure everybody's using their time efficiently. All right, with number 1 and number 2 being answered, question 3 asks the question, does the analysis of number 2 change if attorney A is not partners with attorney B, the partner that owns or has an ownership interest in the title agency, but instead attorney A is an associate of the law firm, and really therefore, I guess you could say, in a subordinate position to the partner who owns the agency. I'm going to just go out on a limb and say I think I would understand that. No, the analysis does not change. If anything, the conflict may actually, those circumstances might create even more of a material limitation on the representation.
Well said, Brian. I agree with that.
What do you think it's more, Brian?
Excuse me, Judge?
Why do you think it's more?
Because of the potential power dynamic that exists between associate and partner. I guess that's where Martin had said earlier, the question for an associate attorney feeling the extra pressure of, if I don't refer this to the person who is my superior, or who has the influence over whether I have a job or not, then that may influence the associate's decision, their independent decision of who to send their client to for title insurance. That was my thought process, but this is open for debate.
I think the answer remains no to number 3, as you've suggested, Brian. I don't think it changes the analysis, and I agree with you. I think the interplay of a partner with an associate injects an element that may compound the problem.
I agree with no as well.
Anyone think this is different? Well, what about a paralegal or a part-time clerk at the law firm? We're going to get an inquiry about that.
Well, I think we probably would be safe on that because they, while they are doing ancillary, they're under the supervision of the attorney, so we don't have to worry about that. It's the practice of law, and so that's where we'd be. So they come to there. Or do you mean from owning the title company? That might totally different dynamic. If the paralegal were owning the title company, I don't know. That would be kind of wild, but it could.
How about let's answer that if that gets presented?
There you go.
I quit if there's any new questions.
How complicated can we make it?
Yeah. Let's not go down there. Otherwise, we're gonna just adjourn for the day, and I'll meet everybody at the local water.
I'm just enjoying these meetings so much. I had to see them come to an end.
Okay. Well, I hear it sounds like the subcommittee, maybe just kind of want to be really clear. It sounds like the subcommittee is in agreement on these answers. We've got consensus. Okay.
You want a formal vote?
I don't.
Brian, can I ask
Yes.
you a question? It's the same one that the judge asked you. And that would be, in your considered judgment, have we jumped the tracks anywhere? I'm very comfortable with where we are.
No.
But if you're feeling any kind of doubt or some reluctance to kind of embrace what or where we've come from, I'd love to hear it now.
Yeah, I don't feel that right now. I may in drafting. Because you all know once you start writing something down, then sometimes thought process takes a turn and so forth. And if that's the case, then I will absolutely bring this back to the subcommittee. I think there's, one of the things, I'll just say this, I appreciate the subcommittee's discussion of, the nature of the imputation, recognizing that personal interest conflicts generally are not imputed, but that the nature of this particular conflict that we're discussing is unique. It is unlike other personal interest conflicts because of its centrality to the legal service that's provided. And I think the notion of the difference between this and other law-related services, I know that was something else that was brought up previously in one of our subcommittee meetings, that providing title insurance is cited as a law-related service, I believe, in the law of lawyering. But it is it's something that, again, is a little different. Like Martin, you said, you're an estate planner and you're offering financial planning services as well. It's not a necessary component of the representation. It is, it's a related service. It's an add-on. And of course, the fact that there are law-related services that can be offered, that's really Rule 5.7 dealing with law-related services is really focused on whether or not the rules of professional conduct and the lawyer's professional standards apply when providing those services. It doesn't necessarily just kind of create a free-for-all, and you don't have to think about conflicts. And so that's the thing that I want to be mindful of in drafting this. But admittedly, there are times when I'm drafting something and I just get that different perspective. Maybe it's a gut feeling that there's just something that's not really meshing here. If that's the case, then I'll come back to you all. But otherwise, I would hope to have a draft. This one is probably going to take a little bit longer. I don't know that we're going to have a draft opinion for review in October at our upcoming October meeting. We have a number of other things that are going on between now and then, but stay tuned.
All right.
Brian, thank you for the hard work I know you're going to keep putting into this one. We really appreciate it very much so.
Well, I appreciate the thoughtful consideration by the subcommittee. This is, and really anybody else who's watching out there, the contributions that everybody has provided, and just trying to find the right answer for the people of North Carolina, has been a great example of what the ethics process should be. So I really do appreciate that. But with that said, Judge, is there anything else that you want to cover today?
No, I just wanted to echo that. I mean, I think the comments were very thoughtful. They were very passionate about the issue. And I want everybody out there that submitted the comments to know that even though there seems to be general consensus among the committee members, this was something that was the product of a lot of deliberation. I know I read all of the comments. I know Brian did. I'm sure most of you did. We would talk about this. We've thought it through. We've devoted a lot of time to it. Brian has been very deliberate, not rushing an opinion, not drafting something just to move it off his desk. And he's still not, he's looking toward past the October meeting because this is going to be challenging. So we do appreciate, we recognize that this is important to those who practice in this area. And like I said at the outset, at the first one of these meetings, it's very important that we get this right.
Agreed.
I thank you all very much.
All right, Judge. Well, then I think we'll stand adjourned, and I'll look forward to hearing from you all. Whenever I get a draft together, I'll send it out to you. Otherwise, but like I said, it may not be until after the October meeting when we meet again to discuss it.
All right.
Tom, thank you for your leadership.
Yes. Thank you, Judge. Thank y'all for contributing. We'll talk to you soon.
Thanks,
All
everyone.
right. We'll
So
see you